Well, good afternoon, Michiganders. It is Tuesday, February 2nd, 2021. February already. Where has January gone? Of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan, and we do not send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in the state of Michigan. Welcome to today's program. Last week's episode, should a married couple have one trust or two? I went through an analysis when you're married, considerations that you should have as to whether you do one joint trust or individual separate trusts. So if that's something of interest to you or of concern to you, or maybe you already have two trusts that were done years and years ago, and you might not really remember why you had two rather than one, and you might be considering changing to replace it with one, I encourage you to listen to last week's episode. I guess kind of staying along that same theme of joint, today's show, should you have joint trustees? But please remember, what I'm about to discuss during this program is, as always, for educational purposes only. It is not intended to be legal advice. As always, you need to work with your attorney to determine what is appropriate for you and your estate plan. Should you have joint trustees? Well, when you're putting together your trust, if that's what you're going to have as part of your estate plan, you're looking at naming successor trustees, who it is that's going to settle your trust after your death. Of course, we're also talking about who's going to be the personal representative under your wills, who's going to be agents under your financial power of attorney, who's going to be agents under your healthcare powers of attorney, who's going to be appointed to make funeral arrangements for you. So we're looking at naming these different individuals, and oftentimes clients who have children are going to ask whether it is better to appoint one child or perhaps multiple children as a joint trustee or as a joint agent or personal representative, etc. So where do we start? Well, we're going to start with the first question. If you're considering appointing multiple children, first question is, how well do your children that you're looking at appointing get along? How well do they get along? If for example, there's already discord in the family, well then having multiple children serving can get ugly very quickly, because now you're taking children who don't already get along and you're forcing them to work together. And that, from experience, does not improve the chances that they will get along. In fact, just the opposite. They will fight even more than they already did when you were alive, when you're calling upon them to work together to settle that estate after your death. And obviously, if that leads to fights between the children, it's going to result in potential multiple attorneys. Children hire their own attorneys to advise them, to represent them, can increase certainly the legal expenses that are going to be incurred in settling your estate. So if your goal is, as most clients, to maintain family harmony after your death, in that case, then appointing multiple children who already don't get along is not going to accomplish that goal. On the other hand, if your goal is to maximize family disharmony, and we did have one client, that was part of his estate planning goal. He wanted his children to fight tooth and nail after his death because he thought they didn't treat him well enough during his lifetime, and that was his way of getting his comeuppance after his death. Now, something else to think about. You might be considering appointing multiple children as your agents under powers of attorney. It could be your financial power of attorney, could be your healthcare power of attorney. If you think about that, now you're appointing children who will be called upon to act on your behalf while you're still alive. You're still alive, but you're incapacitated. Someone needs to make medical decisions for you. Someone needs to manage your finances. And if your children already don't get along, now while you're alive, they're not getting along, can certainly be bad for you. If, though, the children all get along, and you're confident that they will continue to get along, and only you know that, you're the parent, you know your children certainly better than we do, and we're oftentimes asked the question, should we have multiple children? And we will start with, how do they get along? You know them better than we do. But if you're confident they will continue to get along after your death, then having children, perhaps as joint trustees or as joint personal representatives or joint agents, might be appropriate for you. The next question, though, you will have to decide, do you want them to serve as joint, or do you want them to serve as co? Because you'll have those options. What's the difference? Well, when you've got two or more children, serving as joint, or let's take that back. If you have two or more children serving as, for example, co-trustees, then any one of them can take any action that needs to be taken by a trustee without the involvement or agreement of the others. That's the concept of co. They're all equal in that respect, and they all can do whatever needs to be done independently of the others. Joint, on the other hand, for example, joint trustees, means that any action that needs to be taken has to be taken by all of them together. Let me give you an example. Let's say you have real estate, and the real estate is going to have to be sold after your death. If you have children as co-trustees in charge of your trust, then any one of the co-trustees can execute documents necessary to complete the sale. On the other hand, if you have them as joint trustees, then they all would have to sign the documents, including all the documents that are required at the closing. So your decision between co-trustees and joint trustees could also be impacted by where your children are living. If there's a considerable distance between them, then co-trustees might be more appropriate, because it might be more difficult for joint trustees to have to travel and get together to take action in settling your estate. Of course, though, if you want them to all oversee what each other is doing and keep an eye on what each other was doing and make sure everyone is doing the same thing, then you might want to consider appointing them as joint trustees. So, you have to make some decisions. If you're going to have more than one, are they going to serve as joint or are they going to serve as co? And the same considerations are going to apply if you're going to have multiple children serve as personal representatives under a will, as agents under your durable power of attorney, as agents under your power of attorney for your health care, or as an appointing one or multiple to make your funeral arrangements for you. So the same considerations are going to have to apply. You can have them joint or you can have them co. Now, when don't we recommend When don't we recommend joint agents? We don't recommend joint agents under your power of attorney for health care. Why? Let's think that one through. Here's the problem. Medical treatment. You need medical treatment. You have an accident, you have a stroke, whatever it is, the medical condition, you need medical decisions made for you, and you're not able to make the decisions for yourself. So your doctor is going to look at your power of attorney for health care and decide who does he or she need to talk to. Well, if you have named multiple children as joint agents, then your doctor is going to need to talk to all of the joint agents and get their agreement before rendering treatment. Why? Because they're all joint, and that's what you've basically said to the doctor. I want you to work with all of my children. They all need to agree on what my treatment is. Well, you don't really want to find yourself in the emergency room where quick decisions need to be made for your treatment, but they're not able to make them. One, because the doctor's unable to contact all of the agents, wherever they happen to be, and or they're not able to get all of the agents to agree as to a course of treatment. That is why we don't recommend joint agents under a power of attorney. If you're going to have multiple children under your power of attorney, it is much better than to have them as co-agents so that they all have equal decision-making authority, so the doctor can talk to whoever it is that is available. Of course, you might look at that and say, well, rather than that, let me just put one in charge, and then we'll have some order after that. Maybe our oldest is going to be first in line, and if we can't do the oldest, then we're going to go to the second oldest. Whatever it happens to be, certainly you have alternatives to co or joint, but we're now talking about today. You've already analyzed your estate situation, have decided that you do, in fact, want multiple children to serve. But remember, whatever you decide about multiple children, whether they're going to be joint or whether they're going to be co, you need to make sure that your documents are clear as to whether or not multiple fiduciaries are joint and have to work together, or are co with the ability of any one of them to work without others. Why? Here's what we normally find frequently. Banks will treat multiple fiduciaries or multiple agents as joint unless the documents clearly indicate that they have authority to act independently. So let's say you just have that power of attorney prepared and it says, I appoint Bob and Sue and Johnny as my agents. Well, most banks are going to interpret that as appointing them as joint, meaning they all have to participate in any action with the bank. So if you want them to be co, where any one of them can do that, that needs to be clear in the document so that the bank will recognize in that case that they can work with any one of the children. Of course, Amanda and I would be happy to work with you in helping you work your way through that decision as to whether or not multiple children should be appointed and talk to you about the pros and cons of doing that. And certainly Amanda and I would be honored to have the opportunity to help you protect your loved ones by putting together your estate plan, amending a current plan, or perhaps assisting you in settling a loved one's estate. And because of COVID, again, we're not personally meeting with people today. Everything's being done essentially virtually. So if you're a prospective client and looking at someone to help you wherever you happen to be in the state of Michigan, I encourage you, go to Doyle Law PC, click on the Virtual Office tab. There you're going to find information about how we can help you put together your estate plan. It's a pretty straightforward process. You can download a copy of our estate planning guidebook. You can schedule a telephone consultation. It can be a Zoom call or a telephone call, but we'll walk you through, if you go through the virtual office, it'll walk you through the steps that are going to be involved in that. Of course, if you're a current client, we've already done plan for you. You're looking at amending your documents, you're updating it. Head on again over to the virtual office, click on the current client, and you're going to find the Update My Plan service. Simply tell us what changes you're looking at making. You don't have to tell us what documents necessarily, but what you're looking at changing. It might simply be, I want to change this person who was in charge to somebody else. We'll look at that. We'll then determine what documents need to be changed. We'll get back to you about all that. And if we need to have a consultation, again, we can do that by Zoom or telephone. The third option, you simply know that you already need a certificate of trust, or you need a new durable power of attorney, or maybe you need appointments of funeral representative because you don't have those in your plan. Available at Doyle Law PC is our legal store. You can order individual legal documents through the legal store. You can also order them through our Facebook page if you happen to be visiting the Doyle Law PC Facebook page. Well, that is it for today's show on the second day of February 2021. Of course, as always, if you have a comment about the program or a topic that you'd like to have me discuss or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. Also, we invite you and your friends and family, follow us on Facebook and Twitter. That would be Tuesday with Tom. Of course, the office Facebook and Twitter is available at Doyle Law PC. Remember, too, the Tuesday with Tom app is available in the App Store and Google Play. The program's available in many other locations other than just the Tuesday with Tom website. It's available on Apple Podcast, Spotify, Google Podcast, iHeartRadio, Speaker, and many, many more. And you can always ask your smart speaker to play Tuesday with Tom. Well, thanks again for spending some of your time with us today. As always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.